Now, it's a controversial feature of Scots law that split opinion for decades, but could it be nearing its end? Scotland's not proven verdict, according to Holyrood's cross-party criminal justice committee, has had its day. Many argue it offers a vital safeguard in our legal system, but those opposed say it can lead to the guilty walking free. To discuss the issue, we were joined by Ellie Wilson, a rape survivor and campaigner, and the criminal defence advocate Edith Forrest. Edith, so Holyrood's Criminal Justice Committee says the not proven verdict has had its day. Why shouldn't it be abolished?
So in all jurisdictions there are safeguards, and in Scotland that's no different. So although I'm a criminal defence advocate, I also have spent a long time as a prosecutor. I worked for a criminal office and prosecutor fiscal service before I went to the bar. I still do ad hoc ADing, that's prosecuting the High Court. And, you know, I see the criminal justice system, and I've always been interested in just outcomes and a fair system. So, you know, I've heard a lot of people saying that the not proven verdict, just because it's been going for so long, isn't a reason to keep it, but it's there as a safeguard. As I say, every jurisdiction has safeguards. In Scotland, that is a safeguard, and in Scotland we have, we require a simple majority from a jury in terms of verdicts of 8-7. And the not proven verdict is a safeguard. In removing not proven, that removes a safeguard, and there was talk of increasing the majority requirement, so there was talk of changing that to 10-2 or to other tipping points, but that's not been removed. So in effect, the not proven verdict it's removed a safeguard, but there's nothing being put in to replace it, and that's the concern. It's ensuring a fair system, right. And taking that out, in my view, removes that fairness.
Ellie, your attacker was found guilty of 2 charges of rape, and the jurors also returned a not proven verdict on another 2 charges. How do you feel about the verdict of not proven? Did you feel that justice had been served there in the respect of those charges?
Yeah, so for me personally, obviously, I'm in quite a unique position, and for me, I felt that the not proven verdict was actually preferable to a not guilty verdict, because it felt as though the jury did believe me. They just didn't feel like there was a sufficiency of evidence. So that was preferable for me. But I understand that I'm frankly in the privileged position of having actually received some semblance of justice, and my attacker is now in prison. And that for a lot of survivors who receive not proven verdicts, it's really hard for them to feel any sense of closure, because they'll forever wonder, if there was a 2-verdict system, would my attacker be found guilty?
But he was found not proven. That meant he was innocent as far as the law was concerned, but you didn't feel that was the impression it gave?
Yeah, I think that was my impression, but that's also, I think, the impression of the general public at large. The distinction between not proven and not guilty is actually quite difficult to discern, and I think that most people interpret it as meaning that the jury thought the person committed the crime, but they don't feel that there's a sufficiency of evidence, and the research does back that up.
What do you think about that perception, Edith?
Juries do sometimes come back with that question of what's the difference between not proven and not guilty, and they're given the standard direction by the judge that there is no difference. And I suppose that's a difficulty people can't get their head around is, well, what is the distinction? And there's been a lot of focus in this committee as well on, well, we can't really understand it. But as I said at the start, it's a safeguard that's there, and when that's removed, then that's my concern. But ultimately, it's a verdict of acquittal.
But surely it's unfair though for the person that's found not proven, because if people still think that it may have been guilty in some way.
Well, I dare say that even if they were found not guilty, particularly in sexual cases, there is a stigma around it, and I dare say that people will always say, well, there's no smoke without fire. So I don't know that the actual terms being used, and ultimately juries are asked, the question that a jury must answer is, have the Crown proved the charge to the required standard? So it's, have they proved it, and it's by corroborated evidence that's credible, that's reliable. Yeah. So it's, have they proved it or have they not? So ultimately really the question is it proven or not proven?
I mean, there is an argument that if they abolish the not proven verdict, conviction rates would rise. You know, looking at it in that light, would you be in favour of the not proven verdict?
Yeah, and I mean,
abolished?
you know, there was a study in 2019 that looked at this with mock juries, and they found that in finely balanced cases that jurors were more likely to convict someone when the not proven verdict was taken away. You know, we know what conviction rates are like for rape and other sexual crimes. They're extremely low. They're disproportionately low. They're lower than for any other crime type. And I think we really need to have a conversation about what we're going to do to address that, because it's unacceptable. And you know, I do also want to push back on Edith's point about the verdicts not being confusing, because there is a lot of misunderstanding about what not proven means. And in fact, again, there was a review in 2015 that showed that a lot of jurors actually think that a not proven verdict can lead to a retrial, which obviously isn't true.
Well, that's interesting. I mean, do judges make it clear enough? In your opinion, they do?
Yes, that's always part of the direction. That it's, you know, that forms part of the direction. That, you know, it's an acquittal. There's no real distinction in it.
To come back to what we're talking about, how it raises conviction rates if they got rid of the not proven verdict. Groups such as Rape Crisis Scotland believe the verdict is used disproportionately in sexual offence cases. You know, isn't that an issue?
I think where legislation or changes to legislation are based upon an outcome such as raising conviction rates, that's a very dangerous approach to take. So, as I said at the start, my concern is for right outcomes, for fair trials, and if an aim is to raise a conviction rate, then that concerns me deeply. We can't just think, well, you know, we don't like the outcomes, or we've had this law for so long, we need to change for change's sake. That's not how it works. We need to be very, very careful about changes that are made, and the safeguards that are in place for fair trial. And I speak not as somebody who defends people and wants to have them acquitted at any cost. That's not my role. My role is for a just system and the checks and balances that are within that system. And I want just outcomes for everybody, not just for accused people, but I recognise the system that I work within day in, day out. And many people in my position have said to the Justice Committee, you have to be very careful here, and I agree with that.
Having gone through the system, Ellie, what changes do you think should come about?
Yeah, so you know, there has been this discussion about criminal justice reform in Scotland, and there's been a lot of big changes that have been proposed, like getting rid of not proven and like juryless trials. But I actually do believe strongly that some of the most important changes we could make are the most straightforward changes, and those are things like the Crown communicating better with survivors, you know, involving them in the case better, providing psychological support, and also reining in defence behaviour that's inappropriate.
OK, we will have to leave it there, but thank you both very much indeed for joining us. Thank you.
Thank you.